The defense is demanding an emergency hearing regardless, so this is the time that I bring in my experts. Nima Rahmani is a former federal prosecutor, and he's president of the West Coast Trial Lawyers. And Mark Garagos is a legendary defense attorney who once represented Sean Combs. He's also co-host of the Reasonable Doubt podcast with Adam Carolla. All right, Garagos, I'm going to start with you. This feels like it's all-out war well before trial. And I'm wondering what you make of all of this back and forth.
Well, actually, there's a lot that went on today. Part of what the government filed was an admission, if you will, and I'll call it an admission, that they had seized materials from his cell during what they call a pre-planned raid. The problem with that is that they kind of buried in a footnote the fact that they were arguably privileged materials, which prompted the defense to file a letter this morning asking the judge for an immediate hearing and arguing that it was outrageous government misconduct. The prosecutor immediately was ordered by the judge today, this morning after that letter, to file a response by 5 o'clock and set a hearing. The judge set a hearing for tomorrow at 3 Eastern. The prosecutor filed their response at 5 o'clock, and I read it at 5, and I will tell you that it was not what I expected. It basically conceded that they did invade the attorney-client privilege. So they're now hoisted between a rock and a hard place, basically arguing he shouldn't get out of on bail because he can prepare for trial and review the billion terabytes of information while in custody, at the same time saying, well, we're going to execute a search warrant on his cell, and there's an investigator there, and we're going to seize materials, and we're not going to run it through the taint team. I think they've got a lot of questions, or the judge is going to have a lot of questions tomorrow at 3 o'clock, so I would stay tuned. The prosecutors may have bitten off a little bit more than they can chew.
So, Nima, jump in here, because I'm always interested in a taint team. I hate that word, but okay, we know what it means in this perspective. It means you will seize materials, and a special group that is disassociated with the prosecutors look through everything to make sure it's not privileged. I would just assume that all raids of a cell have some kind of taint filter to make sure that you're not taking letters to the lawyer. Why would that not have been the case in Diddy's raid?
It was the case, and the defense has raised all sorts of arguments saying that there's a Fourth Amendment violation here. But we know there's no reasonable expectation of privacy when you are an inmate. Guards can go in there, toss the cell for any reason or no reason at all. You don't need a warrant. You don't need probable cause. And prosecutors in the Southern District of New York, they know what they're doing. You always use a team to make sure that you don't use agents who might accidentally see something that may disqualify the agents and the lawyers who are actually working on the case. And that's exactly what they did here. So I think this is much ado about nothing. We know the defense is always trying to go on the offense, and to argue that the government is doing things that are outrageous. I think Judge Subramanian is going to see right through this and reject this motion outright, because again, the real person that's violating the law here is Diddy, because he's abusing the phone system. He's doing three-way calls. He's trying to obstruct justice. He's trying to tamper with witnesses. And I think it's just a matter of time before he gets hit with a superseding indictment because of everything he's doing.
So that's interesting.
You know,
Mark, the phone system, right? The phone system's easy to check, isn't it?
Yeah, but I'll invite you to save the tape on this, because the prosecutors did an interesting move today. They asked that there was no evidentiary hearing. Last I looked at Pacer, that evidentiary hearing is still on for 3 o'clock. I would say save the tape, because I don't think that this the district court is going to dispense with this so handily. If you read the letter that the prosecutors filed today, it's a very disturbing kind of a recitation of what they did. Nobody is saying that they don't have the right to go into a cell. What they are saying, and what they admitted, is that they had an investigator present, and that investigator saw attorney-client materials, and somehow those materials made it into the hands of the trial team. So, like I said, save the tape and let's replay it tomorrow, Ashleigh.
Let me ask you this, Nima, jump in. If somebody accidentally gets eyes on something, there's something called fruit of the poisonous tree, right? You can't just say, ooh, I see a name, that's handy, I'll go and subpoena that name, because eventually at trial, that will be suppressed based on the fact that it's the fruit of a poisonous look-see. Isn't that something that can be remedied in this case?
Absolutely. We know the attorney-client privilege is the most sacred privilege under the law. I mean, period. So if prosecutors were stupid enough to actually send in agents to go through that material and they have access to attorney-client privilege material, that's a huge problem. I agree with Mark.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.